Breaking, in a historic 9-0 decision, the Supreme Court has just changed the way every American court interprets both the Second and Fourth Amendments. For the first time in decades, all 9 justices, conservative and liberal alike, agreed that the balance between individual liberty and government authority has tilted too far against the people. The case at the center of it all? Barnes v. Felix, a self-defense and unlawful search case that forced the court to answer one massive question. When a citizen faces an immediate threat, from an intruder or even from the state, where do their rights truly begin, and where does government power end? This ruling didn't just settle a legal dispute, it rewrote the relationship between the Second Amendment's right to bear arms and the Fourth Amendment's protection against unreasonable search and seizure. Stay tuned, because over the next 45 minutes, we're going to break down what the justices said, why it matters, and what it means for every gun owner and every American who values freedom. Part 1, The Story of Barnes v. Felix. To understand the magnitude of this decision, we need to go back to where it all began, the story of Barnes v. Felix. Marcus Barnes was a lawful gun owner. No criminal record. Licensed. Trained. A man who believed in his right to protect his home and his family. One night, after a series of break-ins in his neighborhood, Barnes heard glass shatter in the early hours of the morning. He armed himself, stepped into the hallway, and confronted a man inside his home. But what happened next set off a constitutional firestorm. Police, responding to a separate call nearby, entered the wrong house, Barnes's house, without a warrant, and at the moment of confusion, shots were fired. Barnes fired one round in self-defense, believing his life was in danger. The local prosecutor charged him with assault on a police officer and unlawful use of a firearm. The case went to trial, and the court ruled against Barnes, saying the officers had announced themselves and that his reaction was not objectively reasonable. But Barnes appealed, arguing that the trial court ignored the moment of threat, the split second when a person must decide whether to defend themselves. By the time it reached the Supreme Court, Barnes v. Felix had become much bigger than one man's case. It became a national referendum on the right to self-defense, not just from criminals, but from mistakes and overreach by the state itself. And what the court decided would change both the Second and Fourth Amendments forever. Part 2, The Moment of Threat Standard. At the heart of the decision was a simple but powerful idea. You cannot judge a person's use of force from the safety of hindsight. The Supreme Court held that in any confrontation, whether it's a home invasion, a police entry, or a street encounter, the legality of defensive force must be viewed from the perspective of the individual at the moment of threat. Justice Gorsuch, writing for the Unanimous Court, explained. The Constitution protects not perfect judgment, but reasonable reaction under perceived danger. The law cannot demand clairvoyance in the heat of fear. That single line redefines the legal standard for self-defense in America. Previously, courts often applied what's called a retrospective reasonableness test, meaning they looked back, after the fact, at every detail with full knowledge of what really happened. But under the new moment of threat standard, juries and judges must put themselves in the shoes of the defender, at the exact second danger appeared, with the limited information they had at that time. This is a massive shift, one that aligns with the real-world experience of gun owners and the constitutional principle that self-defense is an inherent right, not a privilege. The court compared this standard to similar reasoning under the Fourth Amendment, where officers are judged by what they reasonably perceived when they acted. Now, the same fairness applies to citizens. The result: the law no longer criminalizes fear in a moment of chaos. It respects the human instinct to survive. Part 3, The Supreme Court's Rejection of Narrow Analysis. In the next section of the opinion, the court took direct aim at how lower courts have handled self-defense and gun rights cases since Heller and Bruen. Justice Kavanaugh wrote in concurrence. Too often, courts have treated the Second Amendment as a technical exception rather than a living guarantee. That ends today. The court rejected what it called narrow analytical framing, the practice of slicing cases into isolated facts to avoid addressing the core constitutional question. In plain terms, judges can no longer dodge the Second Amendment by saying, "This case isn't about guns, it's about procedure." The decision forces every court, federal and state, to analyze gun-related incidents under the broader constitutional framework, meaning history, tradition, and the text of the amendment itself must guide every ruling. It's the same philosophy introduced in New York State Rifle and Pistol Association versus Bruin, but now extended to cases involving searches, seizures, and the use of force. The justices said the time for legal technicalities that erode individual rights is over. And in doing so, they sent a clear message: the Constitution does not yield to convenience, and freedom does not depend on hindsight. Part 4: Why this matters to gun owners. For millions of responsible gun owners across America, the Barnes v. Felix decision is not just legal theory, it's a real, practical shift in how the justice system views your right to protect yourself. For years, self-defense cases often came down to one painful reality: the law saw everything after the fact. Prosecutors had time, lighting, expert witnesses, and days to analyze every frame of body cam or security footage. You, on the other hand, had only seconds, sometimes less, to make a life-or-death decision. That's what made the moment of threat standard revolutionary. It finally gives weight to the defender's perspective. The court recognized that when someone's door is kicked in, or when a figure moves suddenly in the dark, the human brain doesn't run through legal checklists, it reacts to survive. Justice Barrett emphasized in her remarks, "A right that punishes instinct is no right at all." The Constitution protects the human response to fear, not only the theory of defense. In practice, that means lawful gun owners now have stronger protection against unfair prosecution when they act reasonably under perceived danger. It also means police and prosecutors must prove, beyond a reasonable doubt, that your response was objectively unreasonable, not simply that you were mistaken. For the Second Amendment community, this is one of the most significant victories since Bruin. It recognizes that defensive action is a right, not a crime to be explained after the fact. Part 5: The Totality of Circumstances, a New Legal Framework. Now, here's where things get even more powerful. The Supreme Court didn't stop at redefining how we view defensive encounters, it introduced a new, totality of circumstances framework. This concept forces courts to evaluate every self-defense case with a holistic lens. What did the defender perceive at the moment? Was there a history of threats or danger? Were law enforcement procedures properly followed? Did government actions contribute to the chaos? Under this framework, isolated mistakes no longer erase constitutional protection. Justice Thomas wrote, "The Constitution does not demand perfection. It demands fairness in context. A man's rights are not suspended because he was afraid, nor diminished because the danger was complex." This ruling bridges a gap that has long divided gun owners and the legal system, the gap between what's legally ideal and what's humanly real. For lower courts, this means more responsibility. They can't pick and choose which facts to focus on, they must consider everything, from lighting and timing to emotion and prior risk. And that standard now applies not only to gun owners, but also to police conduct. In other words, the same fairness that shields an officer's split-second judgment now protects the citizens, too. This is the most balanced interpretation of the Second and Fourth Amendments the court has ever written.
Part 6: Repercussions for State and Federal Courts. When a unanimous Supreme Court speaks, every judge in America listens. The Barnes v. Felix decision immediately forces a recalibration in both state and federal courts. First, appellate courts must now revisit past self-defense convictions that relied on narrow, hindsight-based reasoning. Defense attorneys nationwide are already filing motions to reopen cases where the moment of threat standard wasn't applied. Second, states with restrictive gun laws like New York, California, Illinois, and New Jersey must rewrite portions of their jury instructions and use of force statutes to align with this ruling. Why? Because their old standards often placed an impossible burden on the citizen, demanding proof that their fear was objectively correct instead of reasonably felt. That language is now unconstitutional. In practice, this means future cases of defensive gun use will look very different. Jurors will be told to view the evidence through the defender's eyes, not the prosecutor's. Federal courts, too, are being reshaped. The Department of Justice has already issued internal guidance, warning prosecutors not to pursue self-defense charges unless there's clear and convincing evidence of recklessness or malicious intent. This decision is forcing a nationwide realignment, one that brings the Second Amendment and Fourth Amendment closer together than ever before. Because at its core, both protect the same thing: the individual's right to stand secure in their home, in their body, and in their freedom against unlawful intrusion. Part 7, The Gun Owner's Reality Check. Now that the dust is settling, let's have a real conversation, gun owner to gun owner. This ruling is a monumental victory for our rights, but it also comes with responsibility. The court recognized your instinct to survive, but it also expects you to act with reason, training, and discipline. Justice Alito put it bluntly in his concurring opinion. Constitutional rights are not a license for carelessness, they are a call to vigilance. Every lawful gun owner now has stronger legal ground, but that also means every mistake will be judged by the same high standard of reasonableness. The best way to honor this decision is to stay educated, stay trained, and know your local laws. Carry responsibly. Understand your state's castle doctrine or stand your ground laws. Keep documentation for your training and permits. Because when a right becomes this clearly protected, the only real threat left is ignorance. Remember, the Supreme Court has given us protection, but it's up to us to preserve it. Part 8, The Role of the Second and Fourth Amendments Together. For the first time in history, the Supreme Court tied the Second and Fourth Amendments together in a single ruling, and that connection might be the most important takeaway of all. The Second Amendment guarantees your right to defend yourself. The Fourth Amendment guarantees your right to be secure from unlawful intrusion. When viewed together, they form a complete shield, one that protects both your ability to act and your right to be left alone. The court's unanimous opinion said it clearly. A free people cannot defend their lives if they cannot defend their space. That line will echo through every courtroom in America. From now on, when law enforcement, prosecutors, or legislators attempt to narrow your right to bear arms, they'll also have to answer for your right to privacy and security. This pairing of the Second and Fourth Amendments is the future of constitutional liberty, the defense of both the person and the place. Part 9, What this means going forward. So what happens next? In the coming months, expect a wave of new challenges, both from gun rights advocates and from states still clinging to outdated restrictions. We'll likely see federal courts strike down laws that criminalize standard capacity magazines, excessive red flag abuses, and intrusive firearm registries that violate privacy. We'll also see the Department of Justice re-evaluate how it approaches defensive force cases nationwide. The Barnes v. Felix decision marks a turning point, a moment when the Supreme Court reminded the nation that the Constitution still belongs to the people. For responsible gun owners, it's a vindication of what we've always known, that self-defense isn't violence, it's survival. And for every American, it's a reminder that liberty isn't granted by government, it's protected from it. This has been Firearms Explained. Stay informed, stay responsible, and as always, protect your rights through knowledge. Because the law is only power when you understand it.